Deputy Registrar, can you please commence the proceedings?
Thank you, President Saunders. Good morning. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Belize, monitoring hearing in CCJ Appeal BZCV number 2 of 2014 between the Maya Leaders Alliance and 23 other villages and the Attorney General of Belize. The members of this morning's panel are Mr. Justice Saunders, President and Presiding Judge.
Good morning, everyone.
Mr. Justice Anderson.
Good morning, Counsel.
And Madam Justice Rajnatali.
Good morning, everyone.
May we have the appearances, please? Thank you.
May it please, Your Honor, Nigel Hughes with Ms. Mendez for the appellants.
Yes, good morning again, Counsel.
Morning, Your Honor.
Morning. May it please Your Honors, Andrew Marshallek together with Ms. Samantha Tucker for the respondent.
Yes, good morning, Mr. Marshallek and Mrs. Tucker. Okay, shall we begin by asking each side to make opening statements?
May it please, Your Honor, Ms. Mendez will deliver the opening statements and will address all of Your Honor's concerns today.
Yes.
May it please, Your Honor.
Before you go, Ms. Mendez, I want to recognize Professor Silorio, who is also present. Professor Silorio, are you hearing us?
Good morning, Your Excellencies. Thank you so much.
Yes, good morning to you. Yes, Ms. Mendez.
May it please Your Honors, I also wanted to make a correction on the record for appearances. With us is also Mr. Alistair Jenkins for the appellant.
Yes, very well.
Your Honors, for the opening statement, the appellants don't have a very extensive opening statement, but we would like to begin by expressing on the side of the appellants, as well as the villages, and as well in my personal capacity as an attorney, my condolences for the return of Justice Witts. He was very important to this process, Your Honors, and on behalf of the appellant, I certainly wanted to put on record that we recognize his contribution to the process. We're very appreciative for the patience that he had in this process and his thoughtful consideration for always taking into account what the appellants had to say and for his guidance throughout this process. So we just wanted to put that, since we have not met since his return.
Yes, thank you very much. So it actually marks exactly 4 months since he left us, and we certainly appreciate your condolences.
Oblige, Your Honor. So very, very quickly, Your Honors, just an update. From what I hope that Your Honors glean from our reports, we can say that there have been notable improvements in the communication and the dealings between the appellants, which we are very much appreciative, and we recognize the government for that. Following our May 9th meeting, Your Honors, which Your Honors would have noted that while there had been written communications between the parties had agreed to meet May 9th to try to just discuss the pending issues in person. From the appellant's perspective, I can say that we are very optimistic, particularly when it comes to the policy. We believe that having now exchanged perspectives, Your Honors, and having had that opportunity to discuss, we believe that the policy could be finalized in short order. At the end of that meeting, the appellants undertook to provide further communication to the government, indicating or proposing yet a further proposal, particularly for demarcation. And we intend to do this within a week's time. Your Honor, if I could, is it that there has been a power outage in Belmopan?
Yes, I noticed that, but are you still hearing us, Mr. Marshallek?
Yes, there has been an outage. We're on batteries. I'm not sure how long it lasts, but we're hearing, and it's just that the
Yes.
lights have gone.
Right. Well, I was going to say, when you're no longer hearing us, just let us know, but then you mightn't be able to let us know.
Yes, I can send a WhatsApp.
You can send a WhatsApp. Okay, fair enough. Yes.
Thank you.
So moving on now to the roadmap, Your Honors, I can also provide an update on the roadmap. Your Honors would have seen that in our report, our last communication to the government was largely positive, except that we were proposing that we develop a consultation plan in order to ensure that there's meaningful participation on the bill and that the consultation happens in a managed process. I believe that we were able to agree with the government in principle that they are in agreement that we should develop jointly a consultation plan. However, the government was particularly concerned with any delay that this would have caused to the process, and so the parties agreed that this would happen simultaneously. As the bill is being developed, so the consultation plan should be developed, so that once there is a finalized draft bill, the consultation plan is in place so that it can simply be implemented. When it comes to our concern with respect to FPIC, which has really been a persistent concern, namely the fact that there is what we consider to be a broad carve-out of the obligation to obtain free and prior consent, free, prior, and informed consent. The appellant at that meeting had the opportunity to emphasize and to expand its concerns and to emphasize the importance of consultation. The government indicated that they would take this under advisement and that we would be hearing from the government. Lastly, with respect to Emir Grove and Laguna, the very last communication and what we included in the report, Your Honor, really is where we are with respect to the finalization of the MOU. However, I can happily indicate to the court, and hopefully it remains that way, that there have not been any further flare-ups since the last hearing, and we hope that it remains that way. From the appellant's perspective, we certainly remain committed to support the amicable and peaceful resolution of this dispute. I will close my opening there, Your Honors, and leave myself open to any questions that the court might have.
Yes, thank you very much, Ms. Mendez. Mr. Marshallek? Well, maybe I should ask whether any of my colleagues has any questions for you.
Not for me, President. I'd like to hear first from Mr. Marshallek. Thanks.
Yes. Okay. Yes, Mr. Marshallek?
Yes, Your Honors. Although the documentation might not fully reflect it, it's been a very busy several months trying to move things along in accordance with the roadmap. In January, we sought to move to the appointment of the draftsperson, but the draft of the Mayaland policy itself that would have founded the instructions that draftsperson met such strong and public and vociferous objections that it was decided that it go back for further consultations and adjustment and refinement. And that process did start, and there were further consultations, and a further draft was put forth. And there have been further communications on that further draft. And where we are now is that there was a meeting again on the points of dispute. And I think we're moving closer towards some common ground, although I suspect there won't be complete agreement on all of it in any event. Our own position with regard to it is that we need to press forward with drafting, but we don't want to do that while the consultations are still ongoing. We need to give that a chance to see if we can produce a better result. And that is what we've been doing. over the period too of some concern, and we raised it in the compliance report, is the discovery by the government that some villages have been issuing what we call homemade titles to land, tab 14. We think that has the potential of derailing the process, and we would ask for restraint in that kind of activity. You would notice that the paperwork being distributed bears a logo, the coat of arms of the state, along with others. And it gives the impression that this is some formal documentation, some formal title from the state. And I'm afraid it can lead to unrealistic expectations and hamstring where we can go with these consultations. It might well be some of these things that fuel such strong positions with regard to the policy. We are asking for restraint in this kind of activity on the part of the respondent. Apart from that, matters are as Ms.
Just a minute, Mr. Mashalek. So were there discussions between the parties about the dissemination of the homemade titles?
No, it wasn't raised at the meeting, wasn't dealt with at the meeting. We just raised it. It's been in the compliance report, so they are aware. And in fairness to the respondents, I don't think it's all respondents that are engaged in this activity. As far as we're aware, it's maybe 2. But I don't know that we have all the information either, or are fully apprised as to the extent of what's been happening in this regard.
Yes.
But instead of being confrontational with it, I'm trying to raise it in the tone of asking for restraint in this type of thing, that this won't help the process along, even if only from a political perspective.
Prince, if I may?
Yeah, sure.
I would just want to say how encouraged I feel, having heard from both sides. Like you, Prez, I've been involved in the process really from the beginning. And I'm sure my sister would probably agree that this is one of the most positive set of reports we have had since we started the monitoring process. And this is to be very, very highly commended, both sides, of course, and we like the spirit within which they are working. No doubt in due course, you'll want to hear from the authority, but I just wanted to remind us that we are working towards a deadline which we set ourselves some hearings ago. We want to have the legislation done by October, I think it is, of next year, outside date, so that I'm hopeful that the revised roadmap, when it comes to being finalized, will take that into account, that we really want, to have this thing done within a decade. A decade is a long time. So that is something to be borne in mind. I would like to, myself, as I suspect you would, President, and my sister Judge, hear a bit more about these home titles which are being issued and which has the potential to cause some disruption in the process. I don't know whether the appellants would be able to shed some light on that aspect of it.
Yes. Before we hear from Ms. Mendez on the homemade titles, Professor Solorio, is there anything that you would like to contribute to the discussion thus far?
Thank you so much, Justice Saunders. And I want to start actually by acknowledging also the passing of Judge Witt. I have to say he had incredible contributions to this process. He was a light, I think, in many ways for Indigenous people's rights. And we have all felt that passing. So I just want to begin by acknowledging that. And I also want to commend the parties. I think this is a very important moment. This is a positive moment in which both parties are working, to find common ground, to build that trust and confidence that I think is important in these kinds of processes. And I also want to highlight the importance of what Ms. Mendez said in terms of the importance of a consultation plan, of an FPEC protocol, that does, include, and reflect, all those interests, that are very important, to advance the rights of the Maya peoples. And I also want to echo what Justice Anderson said about legislation. Legislation is critical in this kind of process. I'm very hopeful. I'm hopeful, to see legislation sooner rather than later. And it's great to see, that all these steps are being taken to be able to issue legislation. And I just want to conclude by saying about the Laguna Village that we had, in my capacity, my office has received 3 different complaints on the Laguna Village. They all, throughout the carrying out of my mandate, they all related to flare-ups and reports of violence. So it's very encouraging to hear that there hasn't been any flare-ups, even though we know there's a lot of work to do. So I just want to commend the parties for all of their work and finding common ground. And I'm very hopeful. That this process will have positive results. And thank you so much for the invitation and the opportunity again to be here.
Thank you very much. Thanks, Professor.
President, if I may?
Sure.
Yes, I join with everyone who has spoken to say how much this process benefited from the care put into it by our late brother, Justice Witt. And surely we do miss him. I don't think people outside of the court understand how much we miss him. But I also wanted to say and to ask Mr. Marshak and Ms. Mendez if they could, because I do believe I heard Ms. Mendez speak about the proposed bill and consultations that will take place. I'm just interested to know, President, and I may have missed it, whether the appointment of a draftsperson is on the horizon, so that all these things are ready to go at the same time, because Justice Anderson has very wisely reminded us that we have given ourselves a deadline. Thank you, President.
Yes, perhaps we should hear from Mr. Marshall first on Justice Rajnath Lee's inquiry.
Certainly. Yes, we had received a number of nominations for persons to be appointed a draftsperson. We had considered them and in fact narrowed it to a person, and approval has been given by the government to engage that person. But we refrained from doing that because the draft was still being discussed, and we didn't want to give the impression that we're moving ahead, notwithstanding those discussions. It's a sensitive issue, so we have we're ready to go on it, but we have delayed effecting that appointment until we hear from this last set of recommendations, suggestions from the appellants, so that we can reconsider the draft and hopefully finalize it, and then have that ready to send on to the draftsperson. So that's where we are. We have somebody in mind. We have approval to effect the engagement, but we don't have the draft instructions settled.
And Mr. Marshak, do you have a date in mind when that all should be together, so you can proceed with what should be an important part of this process?
Yes, I think so too, and we wanted to press forward with it, but we also want to be fair to the other side to consider whatever suggestions they make. We haven't received them yet, and maybe Ms. Mendez can give us a better indication of when we might receive them, so that we can consider them for inclusion in the policy.
Yes. Ms. Mendez?
Yes, Your Honors, thank you. In terms of the further communication from our side with respect to the policy, we intend to provide this within a week's time, Your Honors. And so within a week's time, the government should have our further observations or our further proposal based on the discussions that we had in the meeting, and hopefully that can definitely put us now to very close to finalizing the policy, if not to finalizing the policy already. So that's it in response to my learned seniors inquiry with respect to when they might receive those comments. As it concerns the home titles, Your Honors, we, from our perspective, we would definitely be open to supporting a meeting between the government and the village or villages that are participating in this. But I would make two observations, and I can only assume, but I believe, Your Honors, that the logo, the Belizean logo with the coat of arms that my learned senior referred to, I believe it's in fact being used, or it would be used in response to the sensitivity which the communities would have towards accusation of balkanization. I have seen it used very much. The organization also uses it, but the idea is certainly, as I understand it, to ensure that what is being communicated is that this remains Belize and we remain under the jurisdiction of Belize. It's not intended to be any misrepresentation, Your Honor. So I would just make that observation. And the second observation that I would make is that the communities would have the right to distribute residential lots at this time, and they have been distributing residential lots. These certificates are simply to try to formalize that process and give it some formality. Notwithstanding, I appreciate what my learned senior has said, and from the TA's perspective, we would certainly be open to supporting a meeting between the villages that are undertaking that practice currently and the Government of Belize. Our understanding is that it's only one village currently distributing home titles or certificates as such.
Because there is a connection between that activity and the delimitation exercise. And as I understand it, last time I was reading the report sent in, there is still some disagreement, shall we say, with that process. We seem to have moved away from the auto delimitation and be moving towards some circular scheme. And I know that might still be a matter of some contention between the two sides. So until we have the delimitation process sorted out, it's a little bit concerning, perhaps is a word, to have these home titles being issued when we don't have the final settlement of the delimitation. Would you agree that's an issue?
I absolutely appreciate that, Your Honors. I, however, do think that there is a real need for the communities to be able to live their lives, the members of the communities to live their lives. I do appreciate that there are some disputed areas, certainly. And so with respect to the auto delimitation, just to say that that process continues, but it continues as an evidence gathering mechanism. So it's not that it's absolutely not applicable anymore. I do agree that there is a concern and there's a risk perhaps even that the members themselves take and that the community takes by distributing lots that might be in areas that are disputed or that might ultimately not be found to be within their boundaries. And so I think that primarily those areas that are very much in dispute or for which we might say that there is not substantial evidence, I do think that a meeting with the village and the government would definitely be something that would be helpful to the process.
Can you help me with something? I'm not clear how it works. So the DMP, is that the same as the circular scheme for delimitation? I don't know whether it's you or Mr. Marshall who is better placed to answer that question, but I just wanted to understand how it works. I'm not sure how it does.
I can certainly come in, Your Honor, and then perhaps my learned senior can supplement. Where the parties are now is that the DPM, which proposed a methodology by which the communities would themselves be undertaking demarcation and delimitation, because they would be engaging in evidence gathering activity in order to identify what are the areas that they have used, what are the areas that they occupy. That remains. This circular scheme, as we refer to it, was proposed in the previous revised policy. And that was the policy that was shared with us in January. However, as has been stated by my learned senior, there was significant objections that were made to that particular approach. And so what we have right now is essentially that the DPM remains as an evidence gathering tool, and each community that wishes to apply and to have their Maya customary land tenure recognized will then make an application, and then the full extent of their land would be recognized. That is where we are now with respect to that process. The circular scheme was the one proposed in the previous version that was rejected.
Marshall? Anything to add, Mr. Marshall, please?
I see.
I think he's frozen, I think.
Your Honor, I believe that we have lost power in the AG's ministry, so I will be asking him to relocate to this location that I am now. If we may just be given about 5 minutes to do so.
Okay.
You will bring him in from the darkness and into the light, I see.
Yes, Your Honor.
Wonderful.
Ms. Matuk, were you able to assist us with what the issue at hand? Are you in a position, or you prefer to wait for Mr. Marshall?
Your Honor, I would prefer to wait for Mr. Marshall to address the court on that.
Thank you.
Okay, and you have made contact with him to relocate to where you are?
Yes, Your Honor, I have done so.
Yeah, okay. While we wait on him, Ms. Mendez, these certificates of residential lots, are these intended to be sort of interim certificates until there is something issued by the state?
Apologies, Your Honors. Let me just get some clarification where I can. Crave your indulgence.
Yeah, sure.
Your Honors, my understanding for now, as I mentioned, we would be open to further exploring what is going on the ground. However, my information currently is that these certificates are being given in relation to areas where there are already buildings or already houses on. So it's very unlikely that these are areas that would come into contention in the event. in the process of ultimate demarcation. That is my understanding currently, Your Honors.
It's a form of comfort given to people who already have buildings on a piece of land, which will in any event be factored. You see, what is running through my mind is that it would not be helpful, I think, if there is a competing system of certification, one from the state and another one from another body. And so I could very much understand Mr. Marshall's concern. I'm heartened by the recognition that this is something that requires some discussion, because it would be tragic if there is an inconsistency ultimately between some form of certification or title that is ultimately granted by the state and this certification which is being given to persons. But it's a matter which really needs discussion.
I agree, Your Honors.
I just want to make sure that the defendants are in.
Yes, we are here.
You're here, okay, good.
Yeah, okay, great. Yes, Mr. Marshall, you are now in the light, as my brother Justice Anderson was pointing out. We were just having a discussion with Ms. Mendez about the land titles. I don't want us to say, us meaning the bench, to say anything that will exacerbate any differences, but it is certainly an issue which I think requires some discussion between the parties, and I have no doubt that there will be those discussions. You all have been going along in a very convivial matters.
Yes.
Very congenial. And we don't want to say anything to put a spanner in the works.
Yes, Your Honor, understood. And I raised it, I tried to raise it in a gentle way, asking for restraint. Because I recognize as well, we recognize as well that there is a need. There's no doubt about that. But what that need does for us is to highlight that the importance of this process and to remind us that we have to move it along as quickly as possible to a speedy resolution.
Yes.
And in the same spirit, if we have dealt with, meaning if you have dealt with the issue of the circular scheme for, sort of delimitation, or you have a method of dealing with that, we really don't need to go into it. I was just curious as to, for example, how one decided on the radius of the circle. But if there is a process on the way of dealing with the problem, again, that was not acceptable to the appellants, and you have another way of treating it more as fact-finding, then if the problem has been resolved, we really don't need to go back. Just in case, please.
Yes, indeed, that approach has been done away with. It met with a very strong negative reaction.
Okay.
Although conceptually, I thought it wasn't a bad idea. Given the reactions to it, we have rethought it, and there will no longer be any use of it.
Okay. And in its stead, you have what? Some sort of fact-finding, evidence-based, yeah.
You can apply for any space, no automatic recommendation of any space, and certain threshold evidence needs to be, a threshold needs to be met from an evidentiary standpoint as to whether the application is to be granted or not. And it is that setting that threshold requirement that the discussions now center on exactly what it will be.
Got you. Thanks, Chris.
Okay, sure.
President, there's one other area that I saw raised in the compliance reports, and that is a matter, matters that have been taking place in Indian Creek. I don't know if these things have been worked out. I trust that there will be a resolution soon. Ms. Mendez?
Yes, Your Honors. Indian Creek, the situation in Indian Creek has two aspects, as indicated in the report. The first one has to do with the removal of the alcaldes, which we say are the traditional leaders. We question the authority of the government to have removed them, and in particular remove them in the manner that they did so. But that's a matter that has been filed in court and is currently before the High Court of Belize. Relatedly, however, we are also seeing an increase in the interference and in the presence of rangers that have been sent there and that are working for a conservation organization called Yakshe. This is really an extension of the situation that has been reported to the court as well, to the authority, apologies, and as well to the court previously, the presence of rangers in the village that interferes and prevents them from accessing resources. This was briefly discussed at the meeting, and more recently we have received an invitation from the now director of the Commission of the director of the Office of the Indigenous Peoples Affairs for the parties and the interested parties and the persons affected to sit down and meet. Hopefully that does give us some relief. However, it's always open to the village, of course, to present yet another complaint to the authority, which we are certainly seriously considering.
Mm-hmm. So what are the next steps between the parties? Is there a date for a follow-up meeting?
No date yet. As far as the policy is concerned, we're waiting the comments in a week or so. And once we get that, we expect to have a response in another week or two and to move towards appointing the draftsperson in the next 30 days, I would say. With regard to this last issue raised, I believe there are some meetings scheduled. We have spoken to the private landowners because the area in question, the rangers in question, are a result of are governed by private arrangements. It's not the government that's doing it. So we're trying to broker some interim arrangement, not entirely unlike what was done with Yamargrove and Laguna, although the parties seem more ready to agree or to afford some space as an interim measure for the activities to continue, while also protecting the remainder of the private reserve, because it's a considerable amount of acreage that's under that private reserve arrangement. So I expect that to work out. I hope that works out and the meeting set, and those will proceed in the interim. So at least the Indian Creek issue, yeah, we're attempting to resolve. And that's where we are. We have no firm dates set for any meeting. We really need to see what the suggestions are and to have them considered on our end, and then decide what then is the next appropriate step.
Mm-hmm. Okay. There is an issue which we discovered just by chance almost. The Inter-American Commission also has some form of monitoring role, or they expect the state to provide reports to them. We had a meeting with them, not on this issue, just generally. We are and that issue came up, you know, in lieu of having the government be obliged to do double reporting. If the reports that form part of these proceedings could be shared with them, we certainly would have no objections. I don't know whether the state would or whether the appellants would, but it may make for greater efficiency from the state standpoint.
Certainly, Your Honor. And in the last session before the commission, we had indicated as such, and not indicated, suggested that very approach, that we share the reports, that the matter is under active supervision by this court already. There's no reason to duplicate effort, and we will share all the reports in these proceedings with them. I just made an inquiry to see if that has been happening. I think we need to make sure it's being done as a practical matter, but conceptually, ideally, that solves the issue.
Yeah, okay.
Yes, Your Honors, if I may, just quickly
Yes.
add to that. That was the agreement between the parties at the last working session with the commission. Last year, we attended a working session. At that working session, we also agreed, and the state agreed to a visit from the Inter-American Commission. Part of that would also be holding a seminar related to indigenous people's rights. That would be part of the building of public awareness of the nature of the rights in Belize. This we hope happens this year, hopefully in July, but we are also waiting to hear from the Inter-American Commission. So I just also wanted to share that, Your Honors.
Yes.
I could just add one thing, Perez. These are, of course, public proceedings. If the commission wanted to attend, I'm wondering whether there's any objection to that. They could attend as observers, for example, if that might be useful for them and not objectionable to the parties here, since we are all attempting to get to one common destination. Just a thought.
No objection on our end, Your Honors.
Yes.
No, that suggestion, unfortunately, wasn't made at this session. But we wouldn't have any problems with that. But it was thought sufficient that if the reports were shared and they can monitor from afar, it seems that would have satisfied their purposes.
Sure.
But we're not adverse one way or another. Nobody had made that suggestion at the time.
Okay. All right. Well, it seems to me that all that is left is for us to perhaps tentatively or definitively set a date, maybe in the second half of the year, sometime for us to reconvene.
Perez, I wonder whether just to press the parties a little bit more on the timetable, given that we have a terminal date. I understood the appellants to suggest that they will have their comments on the draft policy within a week or so, and the government responds within 2 weeks of that date. And following that, there's expectation there'll be a complete agreement such that the draftsman can be appointed within 30 days. I hope I got that right. I don't know if there is any other milestone thereafter which we could take note of now so that we could work towards those, bearing in mind, as I said, the terminal date of October next year. We aren't privy yet to the revised roadmap because it has not yet been revised, but we would want to get some idea as to how we are moving from this point to the introduction of the legislation, so we can keep ourselves on track.
Yes, President Fox.
Please go ahead. Please go ahead.
No, I also wanted to put in the mix, thank you, Judge, that Mary Grove, that was to be finalized, that MOU. And I take it, Ms. Mendez and Ms. Marshall, there should be something coming out of the meeting or meetings concerning Indian Creek. So perhaps those can also be at least advanced and if not finalized, so that when we do come back, we have all those things already in place, President. Perhaps that may be possible.
So some dates I think could be useful. Sorry, Mr. Marshall. Yeah.
Yes, I just wanted to make clear so the court understands what's happening on the front with the memorandum with Yamaragove and Laguna. What happened is that Yamaragove got new legal representation and the draft was marked up again. And unfortunately, those markups take us further away from agreement rather than closer. We have been trying to broker the arrangement, but I'm afraid during the period on the review, there were movements further away from agreement on those terms rather than closer. So I've shared the comments from Laguna. I think we received them back to Yamaragove, but that back and forth doesn't seem to be moving us towards agreement. I'm not sure. The blessing is that nothing has happened in the interim, but that process is underway, but it's not one that we control. In fact, counsel for Yamaragove was suggesting getting involved in these proceedings directly. I'm not sure how they would do that, but that's where they were going.
Ms. Mendez, can you shed any light on this at all?
Your Honors, what I can say is that I agree with my learned senior that the comments received from Yamaragove, I agree that it did put us further away from agreements. What we endeavored to do with the leaders of Laguna was to strip what was, in our view, superfluous in the agreement itself, language that might be contentious and might not be necessary to establish the very basic interim arrangement that we want to establish. And so I believe that the agreement went from about 5 pages to about 2.5 pages. There was a lot in the recitals. I think that I think there was just an emotional reaction to it and parties attempting to be overly cautious, and I appreciate that. But nonetheless, all we need really is a very basic framework for this particular matter that does not attempt to try to gain any advantage through the MOU for the ultimate dispute resolution, that does not attempt to argue anything of substance through the MOU that really has to be resolved in the dispute. So just to say that that's our Laguna's last attempt to try to get to some agreement for what we consider is just an interim measure that does not seek to resolve anything, and it's just to put in the basic skeleton of what has to be in place for now. That really is where we are, at least from Laguna's perspective when it comes to the MOU. We are hopeful that we can make some headway, but I also agree with Mr. Marshallette that perhaps the written communication has not really taken us much further. But hopefully now that they have counsel, perhaps that might assist.
When you say they have come, what do you mean?
Counsel.
Oh, they have counsel. Oh, I see. Okay, yes.
Just to go back to the timetable then. So I think we're at 30 days, the appointment of the draftsperson, and then what comes afterwards? Would that be reflected in the revised roadmap? Is that the idea?
Yes, Your Honor, and we do have a draft revised roadmap, and there was only one item, really two insertions that the appellant sought to make, both of which, if we agree to, I can try to put it up with the dates, would have the effect of vacating the last 3 dates in the plan, but all the other dates are set, and what it has to do with is this consultation plan. So it vacates the submission of the draft legislation to Cabinet for full consideration and approval, because the consultation needs to take place before, and then collate and submit revisions and presentation to National Assembly. Those are the last 3 steps that are affected by the insertion. But the other dates were agreed to.
Wonderful.
I don't know if you're seeing it on the screen now.
Yes, we are. Thank you. Thank you very much. This is very helpful. I know that
Yes.
we have this. I assume.
So the submission of the first draft of legislation to review panel for consideration was supposed to be May 31st. I don't think we'll be able to meet that now. So we'll have to readjust those dates.
Okay. This document was submitted to us.
I think it should have been. This is the last draft that we met on and discussed on May 9th.
But not this version.
But I think a version would have gone before, but it might not have been quite this one because it's being changed.
Okay. So you would have to adjust some of these dates. For example, the first draft of legislation.
Yes.
What would be not too optimistic, but a realistic date now for the item which is listed at 10, submission of the first draft of legislation?
I think if we move within the next 30 days to appoint the drafts person, then we need to give them some space to work. I would think they would need at least 2 or 3 months to do that.
2 or 3 months.
Realistically.
Okay.
Assuming that's all they work on.
Yeah.
Yes. The question is whether you could then send us a revised revision of the roadmap, so we can, obviously try and keep you honest to the commitments both sides are giving. That would be helpful for us, yeah.
Yes, it's important, and we will seek to do that shortly.
And shortly, within a week or so?
Yes, I think so. What I can do to make it more realistic is to get in touch with the drafts person and get an indication of the time. But we realize that some of these estimates are just round estimates, so that the dates will probably need to be moved at some point in the future again.
Got you. And just to confirm one last thing, the draft policy does deal with the vexed question of third-party rights, does it?
Yes, that is really the crux of where we are trying to figure out, because how we define the threshold criteria will really determine the extent of third-party rights if affected by, and will crystallize the thing in practical terms for us, even in terms of cost of implementation. It's an important consideration. That's why we sought to focus everybody's attention on that consideration at the last meeting.
I was very pleased to see the spirit of, shall I say, concession, which was evident on both sides. And I think without that, you're not going to get anywhere. So I'm glad that both sides are willing to give something in relation to that very difficult issue.
Yes.
Yeah. Thanks, Press.
Yes. Okay. So I'm trying to identify some definitive dates. Can we say that we will get a copy of the revised roadmap no later than the 24th of May?
Yes.
And that the drafts, every effort will be made, that the drafts person will be appointed by the 30th of June? No later than the 30th of June?
Yes.
Okay, so at least we have some concrete timelines coming out of this this meeting. All right, Professor Florio, is there anything that you wish to say?
Thank you so much for the opportunity, and I want to commend the parties again, because this has been a difficult process. And as was said earlier, I do think it's important to find common ground and to continue building an environment of confidence. And it's great that we have a roadmap, that we have dates, and I continue to be hopeful in this process. And of course, I'm attentive of any new complaints or any other ways in which I can support this process. Thank you so much. And thank you all, Your Excellencies, for all the work that you're doing monitoring this matter. I think it's always been incredibly helpful.
Yes, thank you. Ms. Mendes, any closing thoughts, words?
No, Your Honors, just thank you for the guidance.
Yes, okay. And Mr. Marshalek, anything further from you?
Same, Your Honor. I think progress might seem a little slow, but I think the attention of both parties are now focused on the right issues. So we should see some results soon.
Okay, we haven't set a date when we reconvene. Is it customary to set a date at this session? If so,
Yes.
yes. Let us see. I think sometime in the first term of the year. That's between October and December. Maybe earlier rather than later. Sometime in October. Yeah. How about the first week of October? Thursday the 10th. Is that good for the parties?
Yes, Your Honors, that works for the appellant.
Okay, so let's say Thursday 10th of October at 9 Belize time, 11 Port of Spain time. And we will certainly send you a reminder about this.
Yes, we would normally have any compliance reports coming in a bit before the hearing, as is usual.
Right. So we would need some compliance reports coming in maybe by mid-September.
Yeah.
15th of September. When is the 15th? That's let us say the 20th September. That's a Friday.
Mm-hmm. Yeah. Okay.
So we would send the parties sort of I don't want to call it an order, but a timetable of these various things that have been agreed, so that we all have in mind the dates for next steps. The revised roadmap by 24th of May, the appointment of draftsperson by 30th of June, the compliance reports 20th September, and the next monitoring hearing on the when did we say, in October? 10th of October.
Mm-hmm.
Yeah. All right. Well, as I said, today is the fourth, the anniversary of the fourth month that Justice Witt has left us. As a matter of information, his last hearing was in these proceedings. When he met with you in November, he was already very ill, and he actually struggled through that hearing, and then he got progressively worse. But his last sitting as a judge was with this case. So, as you all know, we miss him very dearly, and may his soul rest in peace. Thank you, Counsel, for your attention. Thank you, Professor Solorio, and we will see each other again, hopefully on the 10th of October. Madam Deputy Registrar, you may close the proceedings.
Thank you, President, especially for the nostalgia with respect to Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnath. Thank you, Counsel and Professor Solorio. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you so very much.
Good day. Thank you.
Thank you.
Thank you.